Hello, this is Attorney Brian Pendergraft, and this is the law on tenant holding over in Maryland, and that is Maryland Real Property Code 8-402. And that's what I have pulled up right in front of you. And I have the link to, so you can get to this page yourself, so you can get here. Um, so you can look at the exact web page that I'm looking at. The only difference is that, as you can see, my version is highlighted, and your version is not going to come like that. But I highlighted this. The law doesn't come like this actually. And this is actually just for. It makes it easier for me to just I kind of group the ideas, and it kind of makes it easier for me to go through this statute. But just know that it doesn't come like that. So I have a few caveats. One. Let's see. Caveat number one. I. This is legal information. This is not legal advice. So that's caveat number one. Caveat number two is that this is let's see. Today is what, October 26, 2019. So and this statute is current up until then, but the law changes. So if you're watching this anytime after October 26, 2019, the law may have changed. So that's the other caveat here. And again, this is for general informational purposes only. But if you want legal advice, or you would like to consult with me, my contact information for you to reach out to me is in the description. So, all right, so let's go ahead and get into this, and let's get this wrapped up. All right, so again, Maryland Real Property Code, Section 8-402. And we're going to start here with A1. So, as you can see, or just A in general, so it's A1, 2, 3, and you have all this grouped in the same, orange color. So, a tenant under any periodic tenancy or at expiration of a lease, and someone holding under the tenant who shall unlawfully hold over beyond the expiration of the lease or termination of the tenancy shall be liable to the landlord for the actual damages caused by the holding over. So that's saying that um, landlords can get actual damages the actual damages that they have incurred as a result of the tenant holding over. So moving on to two, damages awarded to a landlord against a tenant or someone holding under the tenant may not be less than the apportioned rent for the period of holdover at the rate under the lease. So this is saying this sets a minimum for a minimum amount that the court must award. They cannot go lower than this minimum amount. Should you be able to request monetary damages, but we'll get into that later, because generally you don't get monetary damages in tenant holding over actions, and I'll explain later when we get to that part in the statute. So let's see, 3 and I. So any action to recover damages under this section may be brought by suit separate from eviction or removal proceeding, or in the same action and in any court having jurisdiction over the amount in issue. So essentially, this is saying that separate suits can be brought. So I mean, you may have a failure to pay rent case going on, but you can still bring a tenant holding over action, essentially. So yeah, you're not barred from filing a tenant holding over action just because you got other things going on. All right, so moving on to this orange section here, the court may also give judgment in favor of the landlord for the damages determined to be due together with costs of the suit. The court finds that the residential tenant was personally served with a summons, or in the case of a non-residential tenancy, there was such service or process of submission to the or submission to the jurisdiction of the court as was supported judgment in contract or tort. So this is essentially, this is what I was saying earlier with, this is how to get monetary damages, and this is why they're generally not awarded. So the key here is that the tenant must be personally served with a summons. So generally what happens is, so when it's time to, in landlord-tenant cases in general. So when we file a landlord-tenant case, a lot of times we pay the sheriff to serve. And when we pay the sheriff to serve, at least where I primarily practice in Prince George's County, and I'm in Montgomery County quite a bit. I'm in Baltimore City quite a bit. What happens is that personal service does not actually occur. Generally, the sheriff, they have lots of people to serve, and they're not trying to personally serve people. They don't have the time for that, so they just post a notice to the door. And that is why, because they post it to the door, it's sufficient notice. I'll explain that later when we get to it. It's sufficient notice for possession of the property, but it's not sufficient for monetary damages, and that's why we generally do not get monetary damages in landlord-tenant court. Generally, in order to get monetary damages, a lot of times we have to go to civil court. But again, I'm not saying personal service isn't possible. You if you would like to get personal service, you generally have to hire your own personal process server to do that. Um, and then it goes on in the case of non-residential tenancy. Uh, Again, that shows the service, the process, submission to the jurisdiction of the court would support a judgment in contract or tort. So, in other words, it is possible to even without personal service, it's possible to request as long as the service is efficient as it would be in regular contract or tort court, or I guess I'll call that regular civil. I'll call that small claims court or law or large claims court as opposed to landlord-tenant court. Then you can get a judgment for possession. Again, I think the judges probably still would like to see personal service, even in like commercial tenant cases. I think to be safe, personal service is probably the way to go. All right, so if you're trying to get monetary damages, but nevertheless, even if you don't get personal service in non-commercial or I mean in commercial cases, you can still go for it, still ask for it. You might be able to still get it. So 3 in this orange section, a non-resident tenant who was not personally served with summons shall not be subject to personal jurisdiction of the court if the tenant asserts that the appearance is for the purpose of defending an in-rem action prior to the time that evidence is taken by the court. So this is saying that a non-residential tenant who was not personally served should not be subject. All right, so this is saying that for again, this is for commercial tenants. So if a commercial tenant appears who was not personally served, they can say before any evidence, if they know this rule, before any evidence is taken, they can say, "Hey, I'm only here for defending the in rem action. I'm not here, that's the only purpose I'm here for." If they assert that, then they have then the court essentially in an in rem action, then the court is only going to award possession. Essentially, they're going to not award monetary damages. It's probably one of the reasons why it's good to have an attorney, because attorneys know this rule. But how are people who don't have attorneys going to know that rule? They don't. Again, need an attorney, hire me. So moving on to 4, this yellow section. Nothing contained herein is intended to limit any other remedies which a landlord may have against a holdover tenant under the lease or under applicable law. So in other words, even if we file for a tenant holding over, get him out for tenant holding over, we can still try to we still have our other remedies. If we still can file a fair interaction, we can still file a civil, just a regular civil contract action, which again you probably have to do in order to try to get monetary damages or all the other any other sorts of damages that you can get as a result of that tenant holding over. It's just that again, that'll generally be done in contract or toward a regular civil case. All right, so moving on to this purple B1I. So where any tenancy is for any definite term or it will, and the landlord shall desire to repossess the property after the expiration of the term for which it was leased, and shall give notice in writing 1 month before the expiration of the term or the termination of the will to the tenant or to the person actually in possession of the property to remove from the property at the end of the term. And if the tenant or person in actual possession shall refuse to comply, the landlord may make a complaint in writing to the district court of the county where the property is located. This is saying that you have to send a proper notice to terminate at least again at least a saying at least a 30-day notice, or 1 month, I should say. 1 month for the expiration of the term. You have to send that notice. That notice has to expire, and when that notice expires, you can file a complaint asking for that person to be removed, and the proper venue is the district court where the property is located. So if you are in where I primarily practice, say Prince George's County, the district court that is the one that we use for landlord tenant cases such as this is the one in Hyattsville. If you're in, let's say, Montgomery County, if that's where the property is located, then the district court that generally hears those hearings is the Rockville District Court. So again, you just have to find the correct district court for where the property is located. So moving on to this yellow section, let's see. It's 2 eyes 1. The court shall, I'm gonna call it as B 2 eyes 1. All right. So the court shall issue a summons directed to any kind. So this is more procedural stuff. So this kind of says that after you file here, so here's if you're ever curious as to after you file, like what does the court do and or what happens, this is it. This is this yellow section here. That's what they do. So the court shall issue a summons directed to any constable or sheriff of the county entitled to serve process, ordering constable or sheriff to notify the tenant, assignee, or subtenant to appear on the day stated in the summons before the court to show cause why restitution should not be made to the landlord. So this is saying that, essentially that the court issues a summons, and then the sheriff will go and serve the summons, and the summons says, "Hey, you need to come to court, tenant or occupant or whoever you are. You need to come to court, and you need to tell and you should definitely come." All right. So two, the constable, the sheriff should serve the summons on the tenant, assignee, or subtenant on the property, or on the known or authorized agent of the tenant, assignee, or subtenant. Again, that generally never happens. So moving on to three, if for any reason those persons cannot be found, the constable or sheriff shall affix the attested copy of the summons conspicuously on the property. So that's what usually happens. So they generally post the notice to the premises. That's what happens. So four, after notice to the tenant, assignee, or subtenant by first class mail, the fixing of the summons on the property shall be conclusively presumed to be sufficient service to support restitution, i.e., you get back possession, not get back possession of the property, not monetary damage. Generally, that's what generally happens if personal service doesn't happen, and it generally doesn't happen. Um, and you see, and subtenant at the notice by first class mail. So that's not something that you have to worry about, by the way. All this stuff in yellow, like once you pay, once you pay your fees, like this notice is going to be sent out by the clerk. They send out the first class mail, the clerk sends out the notice, and the sheriff serves, So once you pay your fee, like this stuff in yellow is all taken care of. Like you don't have to do anything. You don't have to think about it. But again, I'm just going through this statute because that's what I said I would do. I'm going through the whole statute on a tenant holding over. So moving on to 3I. So this is B3. Upon the failure of either of the parties to appear before the court on the day stated in the summons, the court may continue the case on a day not less than 6 or more than 10 days after the date first stated and notify the parties of the continuance. That doesn't happen. So what happens generally is if the landlord shows up and the tenant is if the landlord shows up and the tenant is not present, what the court generally does is, again, that says that they can do it, but this is that they have to, and they generally don't. Do it here in 3. What they do is, if the landlord shows up and the tenant doesn't show up, they generally issue a default judgment in favor of the landlord for possession, or at least they'll have a hearing. And if the landlord can, they can show enough, they can the hearing will just proceed without the tenant being present. The landlord can prove his case, and they will get a judgment against the tenant. If the tenant shows up and the landlord is not present, the case will generally just be dismissed, usually without prejudice, and the landlord would have to file again. So that's what actually happens. All right. So moving to this blue section here. 2I. So if upon hearing the parties, or in case the tenant or person in possession shall neglect to appear after the summons continues, the court shall find that the landlord had been in possession of the leased property, and that said tenancy is fully ended and expired, the due notice to quit has aforesaid have been given to the tenant or person in possession, and that the tenant or person in possession had refused to do so, the court shall thereupon give judgment for the restitution of the possession of said premises, and shall forthwith issue its warrant to the sheriff, the constable, in their respective counties, commanding the tenant or person in possession forthwith to deliver to the landlord possession thereof in a full and ample manner, as the landlord was possessed of the same at the time when the tenancy was made, and shall give judgment for costs against the tenant or person in possession so holding over. All right, so that was a bit of a mouthful. So what this is saying, let's see if I can translate this. Maybe I should have went line by line, because that's a mouthful. But all right, so that's saying if the landlord can prove their case, they can prove they given notice expired, and tenants, for whatever reason, tenants still in possession of the property, and after it's just say the landlord proves their case, what happens is they can get they can get a warrant for restitution. Judge will sign off that warrant for restitution. What that warrant does is it gives the sheriff permission to carry out an eviction. So then the sheriff will tell you and bring your eviction crew to meet us at this time. We're going to we're going to throw this person and the things out and change the locks, and that's how you get back possession of your property. And you can get money again only if you get monetary damages. But essentially, so this is just a long way of saying that we're going to have a trial, and this is the trial. You trial, you have a win, and this is your remedy. You get back possession of the property, and you have personal service. Then we can try to get the money back too. If you have personal service, get your money too, or at least a judgment for the money. All right, so moving on to this, let's see, this blood orange section here. So either party shall okay, I see why this is all orange right here. So this is these are your appeal rights here, all in orange. This is the appeal rights. So either party shall have the right to appeal therefrom to the circuit court for the county within 10 days from the judgment. So translation, 10-day appeal period. You must appeal within 10 days. So let's see. Let's keep going. If the tenant appeals and files with this court an affidavit that the appeal is not taken for delay, and also a good and sufficient bond with one or more securities, condition that the tenant will prosecute the appeal with effect and well and truly pay all rent and arrears and all costs in the case before the district court and the appellate court, and all loss or damage which the landlord may suffer by reason of the tenant's holding over, including the value of the premises during the time which the tenant shall hold over, the tenant or person in possession of said premises may retain possession thereof until the termination of said appeal. All right, bit of a mouthful, but all that's saying essentially is the tenant has a right to appeal. Landlord does too, but tenant has a right to appeal. But this is saying if a tenant appeals, they have to pay a bond. They pay that bond, they can stay. And it's kind of sets the amount of the bond too. So this is saying upon the appellate court shall, upon the petition of either party, set a day for the hearing of the appeal, no less than 5 nor more than 15 days at the application, and notice of the order for a hearing shall be served on the opposite party of that party's counsel at least 5 days before the hearing. So this is saying that let's see, it's saying so this actually doesn't happen for me. So this is good to read. This is saying that let's see. So the appellate court shall set a hearing date not less than 5, no more than 15 days after the application. That doesn't happen for me. I mean, I've never gotten appeal to to happen that quick. So that's just generally not what happens. I wish appeals happen that fast, but I guess the statute is a lot more. It's a lot more optimistic than what actually or yeah, it's dreamland. Appeals take forever, but it is what it is, man. They have lots of cases. There's lots of people that need to be evicted. So I guess in practice, they just get around to it when they get around to it. I'm sure they try to be fast, but 15 days, man, I don't think that they're actually that fast. All right, so moving on to so the law may say something. The law may set the ideal, but in practice, sometimes it just doesn't happen that way. All right, so moving on to number 5. If the judgment of the district court shall be in favor of the landlord, a warrant shall be issued by the appellate court to the sheriff, who shall proceed forthwith to execute the warrant. So I guess it's saying that if in event of an appeal, if the landlord wins, they get an expedited eviction, essentially. Or that's not that's I understand this is the ideal, but that's not what happens. It's your sheriff, your warrants is just sent into the normal course of all other warrants, and you just have to wait until the sheriff contacts you, and it takes forever. But again, there's the ideals, and then there's actually putting this stuff into practice, which again, there's lots of people that need to be evicted, so that's unfortunate, but it is what it is. All right, so this section 3 3I 2 and 3, man, I'm thinking about skipping it, but you know what, let's do it. All right, so it's a bit of a mouthful, but let's do it. We got this. The provisions of this subsection shall apply to all cases of tenancies at the expiration of a stated term. Tenancies from year to year and tenancies of the month and by the week. All right, so this is saying, all right, got it. So at the expiration of year to year tenancies or tenancies of the month and by the week. All right, so that's what we're looking at here. Year to year. So that's regular yearly. That's generally 1 year lease or tenant it's a tenancy from year to year. So I guess that's like a 1 year lease that renews or something like that, right? So that's what we're looking at, a tenancy of year to year. Tenancies of the month to month. Let's see, it's regular, month to month tenancy, and then there's tenancies by the week. All right, got it. So in case of tenancy from year to year, so this is tenancies year to year. That's a tenancy where after a year it may automatically renew to another year, and this is how we I guess cancel those, including tobacco farm tenancies. Notice in writing shall be given 3 months before the expiration of the current year of the tenancy. Okay, so you got to give a 3-month notice if you want a I mean, a 3 month notice. If you want to, if your lease automatically renews, you got to at least give 3 months notice. If automatically renews for a year, you have to give at least 3 months notice. All right. So, except that in the case of all other farm tenancies. All right. So, farm tenancies are excluded. A notice shall be given 6 months before the expiration of the current year of the tenancy. Um. All right. So, wait. Let's see. Let's see. Notice shall be given 6 months of current tenancy, and then all right. Okay. So what that's saying is farm tenancies. Okay, so for whatever reason, farms you got to give even more notice. So 6 months. All right, so let's keep going. And in monthly or weekly tenancies, all right, so monthly or weekly. Now we're back down to monthly or weekly. A notice of writing of 1 month. Okay, monthly you got to give 1 month. Um, and weekly you got to have 1 week. And a notice of writing of 1 month or 1 week, as the case may be, shall be so given. All right, so he's got to get the proper notice for the proper time. So you may want to review that again and make sure that you are giving the proper notice depending on the type of lease you have. It can be a little confusing, but so if you need help, need an attorney, contact me. All right, so two eyes. This paragraph, so far as it relates to notices, does not apply in Baltimore City. All right, so if you are a everything you just heard, if you're probably located in Baltimore City, just throw it out the window and go look at your Baltimore City rules, because apparently you have your own notice rules that just aren't in here. So whatever, you got to look up your local rules for that. Who knows? Maybe I'll go over that in another video. If you want to do that, just let me know. Um, in Montgomery County, Montgomery County got to be special too. Except in the case of single-family dwellings, notice by the landlord shall be 2 months in the case of residential tenancies with a term of at least month to month, but less than from year to year. All right, so you may, in certain cases, you have to give 2 months notice in Montgomery County. Be aware of that. All right, so moving on to this pink purple number 4. When a tenant shall give notice by parole to the landlord or to the landlord's agents or representatives at least 1 month before the expiration of the lease or tenancy, in all cases except in tenancies from year to year, and at least 3 months notices in cases of tenancy from year to, except in the cases of farm tenancy, the notice shall be 6 months of the intention of the tenant to remove at the end of that year and to surrender the property, and at that time, and that the landlord and landlord's agent or representatives shall prove the notice from the tenant by competent testimony. It shall not be necessary for the landlord and landlord's agent or representative to provide a written notice to the tenant. But truth notice from landlord from the tenant, as ever said, shall entitle the landlord to recover possession of the property hereunder. This paragraph shall not apply in Baltimore City. So this is saying, so this is saying that a landlord doesn't necessarily have to give notice. They can go off of the tenant's notice. Again, all right, well, you have it. There it is. So apparently you can, the tenant's notice is sufficient. I mean, I wouldn't, if you really want a tenant to leave, you should probably still send them a notice yourself. But you still have a claim for tenant holding over if you want to go off the tenant's notice. But again, I would recommend sending your own notice via priority mail, so you have proof of sending that notice. But the tenant's notice is a tenant's notice works too, apparently. All right, yeah, the more you know. All right, so 5. Let's move on to this green section here. Acceptance of any payment after notice, but before eviction, shall not operate as a waiver of any notice to quit, notice of intent to vacate, or any judgment for possession, unless the parties specifically otherwise agree in writing. Any payment accepted shall be first applied to the rent of the equivalent of rent apportioned to the date that the landlord actually recovers possession of the premises, then to the court costs, including courts awarded damages and legal fees, and then to any loss of rent caused by the holdover. Any payment which is accepted in excess of the foregoing should not bear interest, but will be returned to the tenant in the same manner as secured by as defined under Section 8-203 of this title, but shall not be subject to the penalties of that section. So, I guess the important part of this is actually the first sentence, not that entire mouthful that I just gave you, which is that acceptance of. So even if a landlord accepts money after a tenant holding over action, it is not let's say even if the landlord accepts money before filing for tenant holding over, or if they receive any money, they still have a right to file for what's it called, holdovers. So that's what that's saying essentially. So you can send a notice and the tenant can pay you, but they don't have the right to pay and stay. You can still get them out of there. And the rest of that paragraph, unless the parties agree to it in writing, because the parties agree to it in writing, then they can pay and stay. But that's only if the landlord, that's only if it's in writing. And then the rest of that paragraph just goes on to state how if what rent should be what the rent should how the rent what the rent should be applied to, essentially, if it's again. But that's not really the issue when it comes to tenant holding over cases. Like, we don't generally, the rent's not the issue. You just want the person to leave. um all right, so moving on to C. Unless stated otherwise in the written lease and initial by the tenant, when a landlord consents to a holdover tenant remaining on the premises, the holdover tenant becomes a periodic week-to-week tenant. The tenant was week-to-week um, tenant before the tenant's holding over, and periodic month-to-month tenant in all the other cases. So this is saying that, so unless otherwise written in the lease and initialed by the tenant. So, ooh, you gotta, that's some good lawyering right there. So, so this is saying that what happens if a lease is a what happens when a lease ends, essentially. So, they generally, um if it's not agreed to in so this is saying what happens when a lease expires, or how does it become a month to month tenancy, does it become a week to week tenancy. So this is saying that, the default rule, essentially, is that it's going to become either a month to month or a week to week tenancy. And it can become, something other than a month to month or a week to week tenancy, but it has to be written in the lease, and it has to be, at least initialed by the tenant. If it becomes, if let's say the tenant plans on this becoming, like, let's say, a year to year tenancy where, it renews for a year or so, then that has to be in writing and signed, essentially. So, and there you have it. So that is the entire statute. That is Maryland Real Property Code 8-402 on tenant holding over. So, if you need an attorney to help you with this, do not hesitate to contact me. My contact information, it is in the. I'm going to put that in the description for you guys, and if you can like and subscribe, that would be great. And feel free to ask. Feel free to ask questions. Feel free to, I don't know, correct me if I did anything wrong. That would be great too. Give me your feedback. Alrighty, take care. Thanks for watching.